Lord, my lady, but before I turn to the law, there's just one point I wanted to pick up on issue 1, which is paragraph 120 of the Divisional Court judgment. So that's Core Bundle tab 5. It's at the bottom of page 58. Right at the bottom of the page, the court says, in our judgment, the PCSPS workaround was put forward by BT as a standalone option without the necessity of the accompanying statutory override for the first time in BT's pre-action protocol letter, by which time the decision had already been taken. We say that's demonstrably untrue. It was first put forward in the letter from Sir Michael Rake on the 8th of March 2016 and extensively discussed thereafter. So that brings me then to issue 3. And the question is, did the Treasury have the power to amend the PCSPS rules using the powers under sections 1 and 2 of the Superannuation Act 1972? And at this stage we're looking purely at the question of statutory vires, the scope of the statutory power. And can I ask you to take up Authorities Bundle 1, where you have the relevant parts of the Superannuation Act at tab 3. The purpose of the Superannuation Act was fundamentally to change the basis on which public sector pension schemes were made. Prior to this Act, all public sector schemes, including the civil service pension scheme, were made by primary legislation. And every time they were amended, they had to be amended by primary legislation. And that was considered to be inflexible and inappropriate. So the idea was to introduce legislation that would give the power to a minister to make and amend public sector pension schemes. And we say that that overall context is important when you're considering the scope of the powers in the Act itself. And the core power is at section 1, subsection 1. The Minister for the Civil Service may make, maintain and administer schemes, whether contributory or not, whereby provision is made with respect to the pensions, allowances or gratuities which, subject to the fulfilment of such requirements and conditions as may be prescribed by the scheme, are to be paid or may be paid by the Minister to or in respect of such of the persons to whom this section applies as he may determine. So that's the core power. And in our submission it is deliberately extremely broad, and it includes the making of schemes to make provision with respect to pensions. And we submit that on its face that is clearly wide enough to include making provision for the increase of pensions in payment to account for increases in the cost of living. It would be surprising if such a power were excluded from the ambit of this very wide statutory power. That is then complemented by section 2, further provisions relating to schemes under section 1, and at section 2.9, any scheme under the said section 1 may amend or revoke any previous scheme made thereunder. So it's clear that there's a power to make schemes that amend earlier schemes. And our essential submission is that those provisions are on their face wide enough to empower the Treasury to amend the PCSPS so as to make provision for uprating of the element of the GMP that was previously provided by the additional pension.
Is the PCSP itself a statutory scheme?
The PCSPS is a scheme made under this power.
So it wasn't made after 72?
Well, there was a pension scheme before 72, but after 72 there was a further scheme made under this power. So the PCSPS is made under this power.
Do we have any copies of that?
We don't have the whole of the PCSPS, but I'm going to show your Lordship in a minute one of the schemes made under the PCSPS, which is directly relevant to this case. And if I can ask your Lordship just to contain your excitement for one moment, I am going to show you a scheme, a PCSPS made under this power, which is of direct relevance.
I assumed that the principal civil service pension scheme was a scheme. You're telling me that there are a number of schemes.
There are a number of schemes made under this power which amend or revoke earlier PCSPSs. So,
I mean, maybe that's a slightly odd way of looking at it. What one
yes.
has, and I suppose it's the way pension schemes generally tend
yes.
to develop. You have a scheme which one refers to as such.
But it's
and
actually...
it goes through various iterations.
Yes, that's right.
With a kind of principal deed and subsequent amendments.
Yes.
And I imagine something similar.
Yes, I'm going to show you. I'm going to show you one in a minute. But can I just take this piece by piece, because this is obviously really critically important, and I'd rather not take it out of order. So that's what we say is the basic power, and we say you would need something very clear and explicit in primary legislation to exclude from the ambit of that broad and general power the making of a scheme, including a rule that provided for the uprating of pensions for inflation. Now, what is said is that the pensions increases legislation, the 71 Act and the 75 Act, are by implication to be read as limiting the ambit of the powers under sections 1 and 2 of the Superannuation Act, so as to exclude from those powers any provision relating to the uprating of public service pension schemes for inflation. That's the case that the Divisional Court found against me. And in my submission, that is incorrect. Now, if we then go to the 71 Act, you have that in tab 2. And you can see at section 2 that there is a provision for future reviews and increases in rates of official pensions. And you can see that at that stage, this is 1971, there's a duty on the Minister every second year to review the rates of official pensions against any rise in the cost of living in the review period, and then a duty by order to provide that the annual rate of an official pension may, if a qualifying condition is satisfied, be increased in accordance with the order in respect of any period beginning on or after 1st of September next. Now, that was the 71 provision. And what that did was to impose a duty on the Minister to uprate pensions in accordance with the cost of living every 2 years. That provision has now been repealed, and the governing provision is now the 75 Act, the Social Security Pensions Act 1975, which you have at tab 5, and this is the provision that are in issue in this case. So if you look first of all at the back, you can see at page 46 that various provisions in the Pensions Increase Act 1971 are repealed, including section 2 that we just looked at. That's at page 46. It's the fourth item down. So what we're now concerned with is the regime under Section 59 of this 1975 Act. And this is the provision which is being said, by implication, to limit the ambit of the power under the 72 Act. Okay? So, Section 59, it's at page 35.
Which tab?
Same tab, tab 5, page 35.
Yes, sorry. Yes.
Whereby virtue, this I should say is a subsequently amended version. It's not the version as enacted in 1975. Whereby virtue of Section 151 of the Administration Act, that's a reference to the Social Security Administration Act 1992, which for the court to note is at tab 7, page 57. A direction is given that the sums mentioned in section 150, subsection 1c of that Act are to be increased by a specified percentage. The Minister for the Civil Service shall, by order, provide that the annual rate of an official pension may, if a qualifying condition is satisfied or the pension is a derivative of substituted pension or a relevant injury pension, be increased in respect of any period beginning on or after the date on which the direction takes effect. Now, Section 150 of the Social Security Administration Act is dealing with the uprating of certain social security benefits to account for inflation. And what this Act is saying is that where the government has decided that social security benefits must be uprated by a certain percentage to account for inflation, they have a duty to apply the same increase to pensions payable to public sector schemes. And your Lordship noticed this morning the use of may. In my submission, the reason it says may is clear because of the following words: may if a qualifying condition is satisfied, or if the pension is derivative or substituted, etc. It's not saying you don't have to make the order. It's saying you have to make the order with this specified uprated percentage, but whether somebody is entitled to the specified uprated percentage will depend on whether they satisfy the qualifying conditions.
Is this common ground?
That's what I would imagine.
It is common ground that it's a legal obligation, yes.
Yes.
It's rather odd wording, because it looks at first glance like a sort of clash.
Yes, but it's not.
Mandatory may and
Yes.
discretionary-
I think yes,
Right.
exactly.
Discretionary may and
Exactly.
mandatory must.
That's right. It's a duty,
Yeah.
but a duty that arises when certain conditions are met.
Yes, I think.
Now, in our submission, there's no inconsistency between the existence of that duty and the existence of a general discretionary power in the Minister to make provision for individual public sector pension schemes to be uprated in line with inflation under the 1972 Act. And the reason for that is the difference between a duty and a power. What Section 59 is doing is establishing an across-the-board minimum regime for the uprating of all public sector pensions that has to be applied. It's the floor. But it does not purport to, and there is no reason to construe it as, limiting the discretion of the Minister to make more generous provision if he chooses to do so, or if he agrees with the members of a particular pension scheme to do so. And there are lots of reasons why a minister might do that. He might most obviously do that if he or a previous government has given an assurance or commitment to members of a particular pension scheme that they would receive certain favourable treatment. And I gave the court the example before lunch of a situation where a promise might have been made to firefighters that their pensions would always be uprated in accordance with RPI. And in my submission, if the general policy decision was taken, as it has been, that social security benefits are to be uprated in accordance with CPI, so that the order under section 150 of the SSPA is then based on CPI, and this duty is then to uprate in accordance with CPI, that would not preclude the Minister from including a rule in the fire brigade's pension scheme saying that if there was a difference to the detriment of the firefighters between the CPI uprating and RPI uprating, they would be entitled to the difference. Now, of course, there might be some years where CPI was more favourable than RPI, and some years where it was the same. But if RPI would result in a higher uprating than CPI, the Minister would have the power to make that payment, and that would be done through an amendment to the scheme rules. It couldn't be done under Section 59.
Is it right that Section 59 only enables the increase to be made by the amount read across
Yes.
from the Administration Act, or is there a discretion for the Minister to...
No, my lord, it is a duty.
I know it's a duty, it's just
Yes.
the question is whether it's a duty to simply replicate the amount in the direction, or whether it's a duty to replicate it, or if thought fit to increase it.
Yes, it's the same percentage, my lord.
Where does it say that? I'm sure you're right. I just can't want to find the right... Oh, by the same percentage.
Yes, it's subsection A. Yes. Now, my lord, this is a critical point, because it explains why the regime under the pensions increases legislation is performing a different function from the general powers under the Superannuation Act. It's setting the minimum floor. It's not constraining the discretion of the government to make more favourable provision where it considers that particular schemes warrant it. So I gave the example where a particular promise or assurance had been given, and of course that is this case. This is a case where the reason why the government is seeking to enhance the uprating of public sector pension schemes is because the government concludes that it's promised to do that. And in my submission, not only is there a power to do that under the Superannuation Act, that's the appropriate vehicle for doing that, because it's the Superannuation Act which is the act which gives general power to the government to make and amend the schemes. What this provision is doing is setting the common floor. So that's section 59.1. We then come to 59.5. And the reason for section 59.5 is inextricably linked with the legislative regime which existed before 2014, before the 2014 Pensions Act. Because what section 59.5 is doing is carving out from the minimum provision for increases that's obliged to be made here, the GMP element that will be provided for by other means. Because otherwise, if you uprated public sector pensions across the board by the same percentage as was provided to social security benefits, the GMP element would get $2 of indexation under the old regime. So if we go to 59.5, we can see how that's done. The increases in the rate of a pension that may be provided for under an order under this section are to be calculated by reference to the basic rate of the pension as authorised to be increased by Section 1 of the said Act of 1971 or by any order under Section 2 of that Act or this section. So that's the old regime under the 71 Act or this new regime under Section 59, but where a person is entitled to a guaranteed minimum pension when an order under this section comes into force, and entitlement to that guaranteed minimum pension arises from an employment from which entitlement to the official pension also arises, the amount by reference to which any increase authorised by that or any subsequent order is to be calculated shall be reduced by an amount equal to the rate of the GMP. Now, what that is telling you is that, in fact, the intention of Parliament is that increases to the GMP to account for inflation in public sector schemes are not, in general, covered by this regime. They are carved out of it. And the reason they're carved out of it is that they're dealt with, when this was enacted, by two other statutory provisions. And the two other statutory provisions are, first, the provisions relating to the calculation of the additional pension, and secondly, Section 109 of the 1993 Act. So the very proposition, which is central to the reasoning of the Divisional Court in this case, that this Act and the 71 Act are a bespoke, comprehensive scheme and the exclusive method of dealing with the indexation of public sector pensions is wrong. Because in fact, this scheme recognises that the relevant type of indexation that we are concerned with in this case, indexation of the GMP, is not primarily within this scheme, it's within different statutory schemes. Now, one of those schemes is now gone, but the other survives. The Section 109 regime still survives. And I want to look at that now. So, if you go on in this bundle to tab 9, you see extracts from the Pension Schemes Act 1993. And we are concerned with Section 109, which is at page 134. And my lords, it is this provision, and not the increases legislation, which was the primary statutory means for indexation of the GMP, and remains.
Sorry, could you give me the page?
Yes, my lord, page 134.
134, thank you. Right, yeah.
So Section 109, annual increase of guaranteed minimum pension. The Secretary of State shall, in each tax year, review the general level of prices in Great Britain for the period of 12 months, commencing at the end of the period last reviewed under this section. Where it appears to the Secretary of State that that level has increased at the end of the period under review, he shall lay before Parliament the draft of an order specifying a percentage by which there is to be an increase of the rate of that part of guaranteed minimum pensions which is attributable to earnings factors for the tax years in the relevant period, for earners who've attained pensionable age and other categories of people. And then it says the percentage shall be the percentage by which that level has increased at the end of the period under review, or 3%, whichever is less. So what that does is to place a duty on the Secretary of State to review the cost of living over the year, decide what the relevant figure is, and either say it's 3% if it's above 3%, or if it's 2%, say it's 2%. And that order is then the percentage by which contracted out occupational pension schemes, private sector and public sector, are obliged to increase the guaranteed minimum pension. Now, as the court will immediately have appreciated, that implies the implementation of that order by the individual occupational pension schemes. And in fact, the 1993 Section 109 provisions have been implemented in the PCSPS through an amendment to the rules of the PCSPS made under Sections 1 and 2 of the Superannuation Act. In other words, the power that we uprating of the GMP has already been exercised in order for that scheme to comply with Section 109. And let me just show the court that scheme. It's at the back of Supplementary Bundle 2. And this is what I said that I was going to show you, Your Lordship, is a scheme made under the Superannuation Act. It's at tab 37, page 424. And as my Lord Justice Henderson was saying, what we see here is, rather than saying it's an amendment to a scheme, it's presented as a scheme, but it's a scheme that's amending an earlier scheme.
Exactly, yes.
Yes, so it's layers upon layers. So you can see here at 424, Principal Civil Service Pension Scheme, Amendment Scheme 2006, number 3. The Minister for the Civil Service, in exercise of the powers conferred by sections 124A and 29 of the Superannuation Act, and now vested in him, after consultation with persons appearing to the Minister to represent persons likely to be affected by it, makes the following scheme, which shall form part of the Principal Civil Service Pension Scheme within the meaning of Section 2 of that Act. So there we see the very power being exercised. If we turn the page, this is an extract from a much longer document, but you see an amendment to Rule 1.13a. And in particular, at little 3, you see a definition of guaranteed minimum. Guaranteed minimum means the guaranteed minimum as defined in sections 14 and 17 of the Pension Schemes Act 1993, minimum pensions for earners, widows and widowers, as increased in accordance with the requirements of section 109 of that Act. So what we see is that the PCSPS has been amended so that the guaranteed minimum pension, which it provides for, is defined to include annual increases in compliance with orders made under Section 109. What was not done was to increase the PCSPS pension, the GMP element of the PCSPS pension, under Section 59 or an amendment to Section 59. It was not done under the 75 Act. It was done by an amendment to the scheme rules. Now, my lords, my lady, in our submission, this does drive a coach and horses through the reasoning of the Divisional Court, because it shows that it's simply not true that the 71 and 75 Acts are a comprehensive bespoke scheme through which all pensions increases under the PCSPS are always dealt with. And specifically, that they're not the statutory scheme by which increases to GMP are dealt with. And never have been. Now that leaves, of course, Section 59A. So if we go back to the Authorities Bundle, tab 9, sorry, not tab 9, it's tab 5. Section 59A is at page 43. And my first observation is that 59A is an unpromising location for what is said to be the comprehensive power and exclusive power for the uprating of the GMP element of public sector schemes, because what it is doing is modifying the effect of section 59.5. The starting point of this statutory regime is increases to the GMP are not within it. This is a tweak to that. And in my submission, what it is intended to do is to give a discretion to the minister to mitigate the effects of 59.5 where they would be anomalous and leave people, individual people or classes of people within schemes without uprating. And prior to 2016, that is the way and the only way that this power was used. It was used, for example, in relation to pensioners resident abroad who did not receive annual increases to the additional pension. And because they weren't receiving annual increases to the additional pension, the element of that was attributed to inflation, the inflation element in the GMP, they were not receiving. And because of the injustice to those individuals within particular schemes, orders were made under 59A permitting them to get their uprating under this provision. And if we look at the wording of 59A, you will see that that is what its purpose clearly is. This section applies where the amount by reference to which an increase in an official pension is to be calculated would, but for the provisions of this section, be reduced under section 59.5 of this Act by an amount equal to the rate of a guaranteed minimum pension. The Minister for the Civil Service may direct that in such cases or classes of case, note that wording, such cases or classes of case, this is clearly designed to deal with individuals or categories of individuals who are being disadvantaged. As may be specified in the direction, no such reduction shall be made, or the reduction shall be of an amount less than the rate of the GMP. Now that's the purpose of 59A. And of course, what you're left with when it's operated is only the power to reinstate the floor, the minimum, the across-the-board increase by the same percentage as that used in the Social Security Administration Act. What you don't have by section 59A or any other provision in this Act is a general discretion in the Secretary of State to give more advantageous treatment to particular schemes, perhaps because of an assurance or commitment made or an agreement following industrial action. Now, we know how this power was used because the government's own evidence explained it. It was Mr. Kirk's first witness statement. So that's supplementary bundle 1. It's tab 6. And it's paragraph 22. He said this, it's page 99. However, as referred to by Mr. Deakins, there were some cases where the system as it was initially introduced did not deliver full indexation of a pensioner's public service GMP. These included, for example, cases where a pensioner lived abroad in a country that did not have a reciprocal social security agreement with the UK, and therefore the pensioner did not receive increases on their state pension. Accordingly, the relevant minister was given a power to direct that in certain circumstances an individual's GMP entitlement should not be deducted from the scheme pension prior to it being increased. Section 59A. To put it another way, this provision allows for GMP indexation to be switched back on. Now, there were 4 such orders made prior to 2016, and they all dealt with those types of cases.
And it's one thing to say they all did in fact deal
Yes.
with limited cases of that nature. It's
Yes.
another thing to say the wording of 59A2 is such as only to permit it in those circumstances.
I agree, my lord.
The words in such cases or classes of case are very general. And why could they not apply to across the board to all classes?
My lord, I accept that, and I don't have to go so far as to say that it's ultra vires for the Secretary of State
Yes.
to use Section 59A in the way that he has.
I was going to ask whether you meant it was implicit in your submissions that the
Yes.
direction made in 2016 was up.
Yes, my lord, it's not. I'm not going so far as to say it's ultra vires at all. My point is addressing, as it were, the opposite submission. That what's said against me, and what the Divisional Court has found, is not just that Section 59A could be construed as at its outer margins as wide enough to permit this sort of direction, but that was its core purpose to such an extent that by implication it is to be taken to have limited what is otherwise obviously the power under the Superannuation Act to make such provision under scheme rules. And that, in my submission, is an impossible
I may have misunderstood the case entirely. I thought that the case of the Secretary of State
Yes.
is that is the only provision by which the minimum pension indexation can be given. And is that wrong?
No, we say that this this imposes a mandatory obligation to provide this degree of uprating, no more, no less than that. So we don't accept that it's a minimum provision which can be exceeded. We say it is the provision.
But the attack that's made is on the increase that was
Yes.
specified, not concerned with anything which is above it.
No.
So I'm trying to concentrate on the validity
Yes.
of what is attacked, which is the direction that was given,
That's right.
2018. That has nothing to do with any increase.
No. Well, we say it has nothing to do with any increase, and that when one's looking.
So, as I understand it, your case on that is that level of indexation, namely that which accords with whatever the direction is under the Administration Act for Social Security benefits, that is the way by which that increase not only can but has to be delivered across all schemes.
That's precisely our case.
That's as I understood it.
But my lord, that's never been the position for the GMP element. It's right that that level of indexation, there's been an obligation on the Secretary of State to provide that level of indexation across all schemes, apart from the GMP element. But the indexation of the GMP element, by that percentage, has never been provided under this regime. It was originally provided under a combination of the additional pension and the Section 109 regime, which was then reflected in an amendment to the scheme rules made under the Superannuation Act. Once the AP falls out of the picture, that regime becomes incomplete. And what the Secretary of State says then is, oh, well, the only way that the gap can be filled is by an order under 59A. And our response to that is that cannot be right, because it has never been the case. It's never been the case that this regime was the primary, still less the only, way of uprating the GMP element of official pensions. That was done by other means. This regime was only ever used to uprate the GMP element in certain exceptional or anomalous cases. So it's really to turn the question that my Lord Justice Henderson put to me about vires on its head. That just as we don't say that it's ultra vires to use 59A across the board, although it's an unorthodox use of 59A, because 59A is meant to deal with certain cases or classes of case. Not everybody It's being now applied to give everybody that uprating. And that's not the obvious interpretation of 59A, but we don't say that's ultra vires. But similarly, we say it cannot be said that it's ultra vires to give everybody that uprating of the GMP that was never provided under this regime. It was provided via the AP, that it's ultra vires to do that through an amendment to the scheme rules. That's the essential argument in relation to issue 3.
Can you help me on another point? Maybe I've just got a bit lost in the maze.
Yes.
In relation to BT itself
Yes.
and the GMP,
Yes.
since the abolition of the AP, what is the position in relation to indexation of accrued GMP entitlements? Is there still an obligation on BT to increase them every year by a minimum amount, or is there no obligation at all?
The answer is, my lord, that in relation to GMP accrued between 1988 and 1997,
Yes.
for all of BT's pensioners, 1997, BT increases GMP up to 3% in accordance with the orders that are made under Section 109. So those are indexed under Section
So that
109.
remains in force.
That remains in force, my lord,
That's what I
yes.
wasn't clear about.
No, that remains in force. I don't believe inflation has been above 3%.
Somewhere.
Well, no, certainly not since 2016, which is what we're talking about. As regards GMP accrued before 1988, that used to be uprated via the AP, BT's position is governed by the 2 interim decisions that we're looking at in these proceedings, the second of which is the one that's under challenge. So far, therefore, as sections A and B of the BT pension scheme rules, BT has been obliged to provide full uprating because of the ministerial direction under 59A. And it's the second of those directions which is the decision challenged in this case, in relation to section B. We accept that section A must completely mirror the PCSPS.
Yes.
So that's not in question. But we say that section B gives a much more limited guarantee. The intention of Rule 10.2 of section B was to entitle the BT section B members to the minimum increase provided for under section 59, not to extra provision made by the government to honour assurances to the PCSPS scheme members.
So does it also follow that so long as the annual rise in prices remains below 3%,
Yes.
below 3%,
Yes.
it's really only GMP before 1988 which is an issue in these proceedings?
Yes, my lord. That's correct. And in relation to section B, it's
And
still,
in
and it's
relation
still,
to section B, I mean.
it's still a substantial sum for
I'm not
BT, as you've seen.
suggesting
Yes,
it's
yes.
I just wanted to
But that's
clear
right.
up.
That's right, my lord. That is correct. Yes. And that reflects the fact that before the 2014 Act, the policy was to share the burden of uprating between the state through the retirement pension and the pension scheme through Section 109. The state has now decided it's no longer going to keep its side of the bargain, but has also decided that it will not impose a general legal obligation on private sector schemes to meet the shortfall, because the policy is not to impose that burden on business. So it's for individual schemes, individual employers, either to negotiate with their employees, or if they've made past assurances that give rise to a legitimate expectation, to honour those assurances. That's the policy. The government then, as employer, implements that policy for its own employees, but does so through a statutory route that imposes it on BT, even though BT hasn't given the same assurances. That's the vice. And we say that the underlying premise of the Divisional Court judgment that the 1975 Act, sections 59 and 59A, are the exclusive bespoke scheme for dealing with the uprating of official pensions, is wrong. They were never exclusive at all, they were only the minimum. And they were never the primary scheme for uprating GMP in any event. So that's the two reasons it's wrong. So on that basis, there's no tension or inconsistency between the general power given to the minister under sections 1 and 2 of the Superannuation Act and the duty imposed on the minister under section 59, with then the modifications that come into play under 59.5 and 59A. There's no tension between those provisions. One is a general power, and the other is a duty to provide the minimum floor. Now, can I then? So that's our submission on this regime. And can I now turn to the Divisional Court decision and identify where we say the court has gone wrong on this point? The Divisional Court deals with it. This is again back to Core Bundle 5. It's paragraphs 137 to 157, pages 63 to 68. So you can see at page 63, paragraph 137, the submission that was made by the Treasury. HMT submitted that the increases legislation provides a specific and bespoke statutory regime for regulating increases to public service pensions in payment and preserved pensions in order to protect their value. It was designed for this purpose, and it is the only legislation which has ever been used for that purpose. Now, my lords, we say that submission is wrong. Its purpose is to provide for the minimum across the board increase in line with the percentage for social security benefits, and it was never the regime designed to provide increases to GMPs for public service pensions, and was not used for that purpose before 2016. Before 2016, cost of living increases to public service GMPs were dealt with through different legislation, partly through Section 109, then implemented using powers under the Superannuation Act, and partly through the State Retirement Additional Pension. So the statement that it's the only legislation which has ever been used for that purpose is false. And if we go to 142, HMT further contended that this is the applicable regime governing indexation increases to official pensions is borne out by practice. Since 1975, there's been an increase order made under section 59.1 in every single year bar 2, in both of which there was no positive inflation in the preceding year, to which we say, well, of course there has, because there's a duty on the Secretary of State to make an order under section 59.1 whenever there's an increase in social security benefits. But that doesn't assist you with the answer to the question in this case. Then, since 1979, there have been 4 section 59A directions, and there has at all times been a section 59A direction in force. Each direction revoked the previous one and added to the categories of cases covered by it. In effect, whenever the government's identified a class of pensioner whose GMP is for whatever reason not being indexed, a 59A direction has been made to index that pension. Now, there's a sleight of hand here in the words, whenever the government's identified a class of pensioner whose GMP is for whatever reason not being indexed. Because what is being quietly ignored and brushed under the carpet is that the great majority of public sector pensioners' pensions, the GMPs, was being indexed. And it wasn't being indexed under section 59A. It was being indexed under a different legislative regime. And that's why this whole argument is wrong. The impression that's being given here is the whole question of indexation, including the indexation of GMPs, is dealt with under the 75 Act. That's not right. So then, if we go on, in fact, the only time before the decision challenged in this case that Section 59A has ever been used for an across-the-board increase to GMP was in March 2016, the explicitly interim measure prior to consultation and said to be subject to full consultation that we looked at this morning. Now, the core reasoning of the Divisional Court is at paragraph 156, page 67. And they start by saying that the Treasury's case as to the applicable statutory regime is correct, largely for the reasons given by it.
Hang on, let me see. So which paragraph?
It's paragraph 156, my lord,
Yes, thank you.
page 67.
Yes.
So, first of all, they accept the Treasury's submissions, which I've already indicated were wrong. Then they say the starting point is the 71 Act. It was introduced for the specific purpose of providing for increases to official pensions to allow for inflation. Sections 59 and 59A have effect as if contained in that Act. The 72 Act established a general power to establish public sector pension schemes and to make the rules by which they're governed. Although the powers conferred thereunder may be wide enough to amend PSPS rules to provide for pension increases, the Act says nothing about providing for increases, still less increases to allow for inflation. Now, with respect, that is a very strange paragraph. Is the court saying that as a matter of statutory interpretation, the 1972 Act is or is not wide enough to give that power? Because that's a critical question. And the fact that the Act doesn't specifically mention a particular type of pension scheme rule is, in my submission, neither here nor there. Then, 3, sections 59 and 59A set out a detailed and self-contained regime for the indexation of official pensions. Now, my submission is that's a mischaracterisation. They set out a mandatory regime for a duty to set out a minimum indexation. They're not exhaustive, they're minimum. Then there's a summary of 59.1 and 59.5. And 59A direction is the specified means by which, for classes of case, that deduction is not to be made or not to be made in full. The statutory scheme is, therefore, for indexation increases to be specified under 59.1, but for indexation of the GMP element to be switched off under 59.5, unless for any particular class of case there's a contrary direction under 59A. To allow general powers under the 72 Act to be used to specify indexation increases would be contrary to and undermine this carefully structured statutory regime and thereby conflict with it. Now, what is missing from this analysis is any appreciation of how indexation of the GMP worked before 2014. And the fact that that indexation was in fact undertaken under general powers exercised under the Superannuation Act, as the court has just seen. They then repeat the point that the 72 Act says nothing about increases or about how the GMP element of such increases is to be addressed. Now, that's true. The question of how the GMP element was to be addressed was dealt with in Section 109 of the 1993 Act and was then incorporated via a scheme under Sections 1 and 2 of the 72 Act. And then this, and this is the key error at paragraph 6, the obvious intent of Parliament was that it was the increases legislation, and that legislation only, that should be used for increases to official pensions to allow for inflation. That is wrong. It ignores the way that the GMP has historically been indexed. Official pensions, the GMP element of official pensions has been indexed under legislation that is not within the scope of the increases legislation, and it still is, because Section 109 remains in force and official pensions are still being indexed under orders made under 109 pursuant to the scheme we've looked at. It is not necessary to resort to canons of construction to arrive at that conclusion, but it's further supported by the principle generalia specialibus non derogant. Now, we submit that's just wrong. The court will have seen that we referred to a judgment of Lord Neuberger, which makes the obvious point that it's only if there is an actual inconsistency between two statutory regimes with overlapping purposes that you would treat one as by implication to be narrowly construed so as not to trespass on the territory of the other. And here there is no inconsistency. One regime gives a general power to make any kinds of rules in relation to pensions. The other regime sets a floor for minimum provision. Then at 7, they disagree with that analysis. They say they're not overlapping provisions, still less, as in Cusack, overlapping provisions in the same statute. I'm not sure that makes a difference. They're different statutes addressing different purposes. The increases legislation addresses increases in official pensions to allow for inflation, applies across the board to all official pensions. The SAA addresses establishment and government of individual pension schemes. Its focus is those schemes and their rules, not official pension indexation increases. Again, ignoring the regime entirely by which GMPs have been increased. The issue is not, as much of BT's argument assumed, whether the 72 Act can ever be used to effect a pension increase for a PSPS, but rather whether it can be used to carry out in whole or in part the indexation increases provided for under the increases legislation, thereby cutting across and supplanting the 59-59A statutory regime. Now, in my submission, there is no cutting across, because the 59 and 59A regime was never designed as the exclusive bespoke scheme for GMP increases. So, for those reasons, in our submission, the Divisional Court has erred in law in its construction of the relevant statutory powers, and accordingly erred in concluding that it would have been ultra vires for the Treasury to introduce the necessary top-up indexation, because of the assurances it had given to its own scheme members, by amending the PCSPS. That's issue 3. That then brings me to issue 4, which is...
Was the judge referred to the amending scheme pursuant to Section 109, to effect of 109?
No, my lord, that only came to light about a week ago. But the general submission was made, but that specific amending scheme was not shown to the court.
We can hardly criticise them for failing to deal with it then.
Well, not for that, my lord, but for failing to deal with the whole regime under Section 109, which is the larger point, that GMPs have never been indexed, primarily, under 59 and 59A. But my lord, of course, it's a question of law, so...
And I'm not saying it can't be raised now, but
No.
in terms...
My lord, I'm not in the business of criticising anybody, but simply in trying to get the right result. That brings me to issue 4, which is the question of improper purpose, and we submit that this is really an extremely weak point. It's essentially misconceived. Can I address it by reference to the Divisional Court judgment? It starts at paragraph 158. So you can see the issue summarised. It's page 68. Whether there was no legal power under the 72 Act to amend the PCSPS scheme rules because this would be using statutory powers for a private collateral purpose. And they start with some uncontroversial propositions of public law. The proposition in Padfield that a statutory power must be used for a public purpose. And then Lord Bridge in Chetnik Developments, statutory power conferred for public purposes is conferred on trust, not absolutely. It can validly be used only in the right and proper way, which Parliament, when conferring it, is presumed to have intended. And then they cite cases concerning the abuse of public law powers in order to confer private benefits on individuals. One is about compulsory purchase powers that were used to benefit a landowner by giving him a road across a useful part of his land, rather than for the benefit of the public. And the other is the notorious case of Porter and McGill about the gerrymandering of housing in Westminster, where you see the extract at paragraph 161, a public power is not exercised lawfully if it's exercised not for a public purpose for which the power is conferred, but in order to promote the electoral advantage of a political party. Now, all of these propositions are fundamental to public law and are uncontroversial. But with great respect to the court, they have no application here. The situation here is that the power that we are submitting could, and therefore should, have been exercised is the power under the 72 Act to amend the PCSPS scheme rules so as to provide for the top-up indexation of GMP that's no longer provided by the AP through the scheme rules themselves. Now, what's said is it would be improper to use the power for that purpose because you'd be doing it to confer a private collateral benefit on BT. Now, we submit that's completely the wrong way of looking at it. The position here is that the government itself has identified that the reason it needs to uprate the PCSPS to fill the AP gap is because of assurances it gave to PCSPS scheme members, or that previous governments gave to those scheme members, to the effect that their GMP would always be fully indexed. It's therefore seeking to meet its obligations to the members of that individual scheme because of its own historical conduct towards those members. The government doesn't dispute that that policy applies to public sector schemes but doesn't apply to BT. The government ex hypothesi, because we only get here if I'm right on issue 3, the government ex hypothesi has 2 statutory powers that it can exercise to achieve that route. One is a ministerial direction under 59A, and the other is an amended scheme under the Superannuation Act. If it does the ministerial direction under 59A, it will have an inadvertent impact on BT that doesn't fall within the scope of its policy purpose. And if it amends the scheme rules, it will benefit those that it intends to benefit without having an impact on extraneous third parties. How can it be improper for it to take the latter course?
Well, this really brings us, I think, to a point that I was seeking to get some clarification
Yes.
before, but I think I'm not alone in this, which is to understand what it is you envisaged would be the amending provision to go into, in this case, it would be the British Telecom scheme. It
would be the PCSPS.
The PCSP, I
Yes.
see, that, sorry, to go into that scheme.
Yes.
Well, all right, that's true. At the moment, we have in relation to a certain group of GMP, members entitled to GMP,
Yes.
between certain dates, the people who benefit under the amendment to Rule 113A, which gives them the minimum guaranteed in accordance with Section 109. So we've got the scheme that was, we've got the amendment to
Yes.
Principal Civil Service Pension
Yes.
Scheme,
Yes.
in relation to those
109,
entitled
yes.
to BNP between certain dates.
Yes.
I think it was 88 to 90,
97.
97.
Because there's no accrual after 97.
No, they were anything with the people before then. But they get an increase under the amendment to the scheme, which
Captured
we draw
3%.
ourselves,
Yes.
and that's by reference to Section 109.
That's right.
So what is guaranteed to them is an increase in accordance with the requirements of Section 109 of that Act.
That's right.
Well, what I'm trying to understand is if we amend the Civil Service Pension Scheme,
Yes.
as I understand it, effectively, is this right to cross-reference that scheme to increases under, but to the increases that would otherwise be given under 95A? Is that right?
No. Well, what you'd be seeking to do is to amend the PCSPS
Yes.
so that where people had GMP accrued before 1988,
Yes.
that would also be uprated to account for inflation. Because at the moment,
But it may be inflation, or maybe it depends how they calculate. It depends how the increase is done for social security benefits.
that's right. Now,
Whatever the
you could.
method is.
There are a number of different ways you could do it. One way you could do it would be just as you've got Rule 113A that says it's GMP uprated in accordance with 109. You could have a similar provision that says it's the GMP uprated in accordance with the percentages applied by the Secretary of State under Section 150 of the 1992 Act. So you could have a cross-reference to the 1992 Act, just as you have a cross-reference to the Section 109. That would be one way of doing it. Now, my Lord, I'm not going to stand here and attempt to draft a pension scheme rule on the hoof. We will try.
I think we need to have an idea.
Yes,
of what's going
my
to
Lord,
be.
we will seek to provide at least a rough outline of the sort of language that will be used overnight, but it will have to be tomorrow morning. My apologies. But that's certainly one way you could do it. That as well as having a cross-reference to increases in accordance with 109, you could have a cross-reference to 150.
Right. And you say the effect of that is you would never need to use 59A.
That's right.
You don't need to use.
You wouldn't need to use 59A because you would be providing the indexation of the GMP element under the rules of the PCSPS.
Yeah. And then looking at the position of the BT pensioners,
Yes.
there's an issue of construction which is deliberately off limits, which is
off
whether
limits. Yes.
the reader cost will still apply. But assuming the reader cost did not apply,
Yep.
then the position of the BT pensioners is that they still get the annual 3% maximum uprating pursuant to Section 109.
That's right.
But that's it.
That's right. So the position would be
For that category,
Yes.
category of
But
members.
for the
That's
Section
right.
B members.
That's right, for the Section B members.
Section B members.
yes. I'm going to come back to this when we deal with issue 5 in a little more detail. But
Yes.
but the submission is simply, and subject to the question of construction, which we're not,
Yeah.
but on BT's construction, what Rule 10.2 does is to say you're entitled to the mandatory across the board minimum increase under Section 59 and 59A. You're not entitled to increases to PCSPS given by any other provision. So if the government agrees with the PCSPS scheme members to increase their entitlement by amending the PCSPS, then that doesn't affect the BT scheme members' Section B entitlement.
Is it, does the Section B membership
Yes.
include? I assume it does. It includes people who have GMP before 1988.
Yes.
It does.
It does.
Yes. So that's the category we're talking.
That's the category.
We're talking about the category who combine both
Yes.
Section B membership and GMP before 1988.
That's right. and potentially if inflation were to go up. But
Yes.
we'll leave those out of account.
Sorry, and also to be absolutely clear, there's no question that BT seeking to contend it's no longer subject to Section 109
No.
in the future.
No.
That's a point which I hadn't really grasped
No.
until quite recently.
No, Section 109 remains in force.
Yeah.
So, my lords, I was dealing with issue 4, improper purpose. And my essential submission is it cannot be improper for the government, when it has available to it 2 statutory powers, to use the one which fully meets the public purpose that it's seeking to fulfil, but avoids what the government accepts as an inadvertent knock-on effect on a third party. This is not a case of abusing a power to provide a collateral illicit private benefit. It's a case of a proportionate use of a power to meet the public policy objective and go no further.
Can you just remind me of one thing? I mean, the reason that there's a reference in 59 and 59A, which there is, in clause 10,
Yes.
does that date from the time when BT was effectively a government industry?
No.
When does that date from?
59 and 59A, of course, are more recent. Well, no, sorry. Well, 59A is more recent than 59.
Yeah,
But essentially, what you have is 59 is the mandatory across-the-board minimum. 59A is dealing. Remember that what this does date from is the period where the legal regime assumes that the state is picking up a chunk of GMP indexation through the AP. And the reason there's a reference to 59A is that there are some categories of pensioners who don't get the AP increase, for example, if they're living abroad. And so it's making sure that they don't lose out. That's all.
Yes, but I'm just trying to. So, can you just remind when did the privatisation take place?
84. 84.
And do we have a date for when clause 10 came into being?
It was there in the post office scheme, which was in existence from 1969. So BT was spun off from the post office in 1981.
Couldn't have been the same form.
It didn't refer to 59A, but the increase rule, there was an increase rule that referred to increased legislation, then the Pension Increases Act, back from 1971 in the post office scheme. I know the friend's absolutely right to say obviously that didn't refer to section 59A or anything like that. Right. But what happened when the BT scheme was set up in 1983 after the spinning off of BT from the post office in 1981 was that was intended to be a mirror scheme to the post office. So sections A and B of the post office scheme were then replicated in the BT scheme.
Thank you very much. Yes. Sorry.
So the Divisional Court used against us, I'm still on issue 4, used against us the example of the abusive use of a compulsory purchase power to give a private benefit. But in my submission, a better analogy would be this. If you had a situation where, as in the case that Lord Newburgh considered, you had 2 alternative statutory powers which had overlapping provisions for compulsory purchase, and one permitted the state to make a compulsory purchase of individual properties, and the other permitted the state to make a compulsory purchase of a whole street. And let's say that in order to run a railway line, it was necessary to purchase one property. What the Divisional Court has found in this case is the equivalent of saying it's improper for the state to use the power to purchase one property instead of the power to purchase the whole street. because by using the narrower statutory power, they've given a private collateral benefit to the other houses in the street. And we say that is a nonsense. The other houses in the street didn't fall within the scope of the public policy that they were seeking to implement by the compulsory purchase. So why would they need to use that power? And we say it's turning the doctrine of proportionality on its head to say that that is improper. Now, can I just refer you to my skeleton argument where we deal with this in more detail? It's tab 2. We deal with issue 4, starting at page 26, paragraph 96. And if I can just refer you specifically to paragraph 103, where we make the point that the legal test for proportionality, as defined in cases like Huang, requires there to be a balance between private interests that are adversely affected by state action and the pursuit of a public purpose. And we say it is a nonsense to suggest that it's improper to take private interests into account. It's actually required for the state to take into account the impact that its actions will have on private interests. And of course, that's reflected, it's completely reflected in the consultation paper in this case. One of the main purposes of this consultation paper was to gather information about the impact of this policy on private sector schemes and consider how they could be mitigated.
So in your cases, the Treasury got the matter completely the wrong way around.
Yes.
What they should have done, the only sensible course of action open to them, was to choose the course of action that didn't have a knock-on effect on BT.
That's right, my lord.
Whereas I'm trying to say the only course
Yes.
open to them was to adopt a course which did have that prejudicial
Exactly.
effect.
Even though they accept that the reason they were taking this action was to honour assurances made to public sector pension schemes and that wasn't relevant to BT.
And they recognised explicitly that the effect on BT was in the first.
Yes, and also the specific government policy was not to impose this obligation on private sector schemes because it was a burden on business. So the net effect of this is that an enormous cost is now being imposed on BT, which puts it at a competitive disadvantage when it's competing in the private sector because none of its competitors have had the same cost imposed on them. So that's the improper purpose argument. Can I now turn to issue 5, which is the question of property rights under Article 1 of the first protocol. And my lords, my lady, in my submission it's important to understand the premises on which this issue arises. First of all, it arises on the premise that under Rule 10.2 of Section B of the BT pension scheme, members have a right to increases provided under Section 59 or 59A, but do not have a right to increases provided to PCSPS members by any other legislative route, including by amendment to the PCSPS under the Superannuation Act. So that's the first factual premise. Now, if we're wrong about that, and in fact Section B members have a comprehensive right to receive any pensions increase that PCSPS members receive by any route, then there's no issue under Article 1 of the first protocol because whatever route was adopted, BT would be liable to provide it to the Section B members. So the first crucial is that Section B, paragraph 10.2, is a limited right. It mirrors the minimum, but it doesn't give you every increase. The second essential premise is that the government has the power to provide the increase to the GMP to PCSPS members by means other than Section 59A. including in this instance amendment to the PCSPS under sections 1 and 2. Because again, if we're wrong about that, the government has to do it under 59A, then you never get to any question about property rights. So those are the two key premises, that it's a limited, the right is of limited scope, and the government has the power to increase pensions by other means that are not within the scope of 10.2. Now, what the Divisional Court has found is that in that situation, BT Section B members have a legitimate expectation which amounts to a property right under domestic law or under Article 1 of the First Protocol, and we're going to come in a bit later whether there's any difference, that the government will never increase PCSPS pensions by any means other than a ministerial direction under Section 59 or 59A. In other words, a legitimate expectation that the government will never exercise the power that it ex hypothesi has to increase PCSPS pensions by amending the rules. And the Divisional Court has made that finding not on the basis of any promise or assurance or commitment that it says was ever made to the BT scheme members, but simply on the basis of what it characterises as an invariable administrative practice, that all increases to the PCSPS have been increases under 59 and 59A. Now, we say that's unsustainable in law and in fact. As a matter of common sense, it is very difficult to understand how, if a pension scheme gives somebody a limited right to a particular increase, if a particular legislative route is followed, that alone could give them a legitimate expectation that no other route would be followed to give an increase. It's a very strange proposition. The court has seen the very different drafting of Section A of BT's pension scheme. And Section A, which is very clearly intended to ensure that those pensioners have the maximum benefits attainable under the PCSPS, doesn't limit that right to any particular legislation. It goes out of its way to say any means by which the PCSPS is increased will apply to Section A members. Can I just show you that before we move on? I know we've already looked at it once. It's at the back of Supplementary Volume 2, tab 36. And in the middle, it's page 417. What the Section A members are entitled to are the like superannuation benefits as the maximum benefits which could be paid to or in respect of such member under, notice this word, the enactments and instruments relating to superannuation in the civil service, as hereafter varied from time to time by any future enactments or instruments, as if his or her principal company employment were service of the designated category. Now that's the sort of language that would give you the kind of legitimate expectation that this court's been talking about. The obvious implication of language that limits your right to increases provided under specified defined legislation is that you don't have that right if the increases are provided by other legislation. Now, turning then to the applicable principles, there are two key decisions of the European Court of Human Rights, which we just need to look at briefly. The first is the case of Kopecky. That is, I have it in Authorities Bundle 2, tab 31, but I've now lost confidence that my Authorities Bundles are the same as your Lordship's. I think the tab numbers at least are.
It's
Volume 1. Volume 1, tab 31. Kopecky and Slovakia. The facts of this case are not important. It is the summary of the general principles in which a property right arises.
So which is the tab number?
Tab 31, my lord. The summary of the general circumstances in which a property right arises under Article 1 of the First Protocol. It's page 831 and it's paragraph 35. The following relevant principles have been established by the practice of the Convention institutions under Article 1 of Protocol 1. Deprivation of ownership or of another right in rem is in principle an instantaneous act, does not produce a continuing situation of deprivation of a right. Article 1 of the First Protocol does not guarantee the right to acquire property. An applicant can allege a violation of Article 1 of the First Protocol only insofar as the impugned decision related to his possession within the meaning of this provision. Possessions can be either existing possessions or assets, including claims, in respect of which the applicant can argue that he or she has at least a legitimate expectation of obtaining effective enjoyment of a property right. So that's the scope, a legitimate expectation of obtaining effective enjoyment of a property right. By way of contrast, the hope of recognition of a property right, which it's been impossible to exercise effectively, cannot be considered a possession. And nor can a conditional claim which lapses as a result of the non-fulfilment of the condition. So in my submission, I hope that future increases to the PCSPS would be provided under section 59 and 59A is not a property right, and neither is a conditional right to increases under that legislation a property right that's interfered with when an increase is provided under a different piece of legislation, simply that one of the conditions of your property right wasn't fulfilled. The question that the scope of your property right is only a right to increases under the specified legislation. So that's the Kopecky principles. There is then a case that was relied on by the Divisional Court, a case of Stretch in the United Kingdom, which is in the previous tab, tab 30. And this is the high watermark of what the European Court of Human Rights means by a legitimate expectation of the effective enjoyment of a property right. What happened in this case, as you can see from the head note...
Can I just ask you this question?
Yes.
Is the submission you make on the basis of Kopecky
Yes.
that the right under the right of members of the B group, the B members,
Yes.
to increases which have been granted under 15, to equivalent increases
Yes.
to rights which have been granted under 59.1 and 59.5 is not a possession for this purpose.
No. My Lord, we
It's a
accept
possession.
that the right to increases granted under 59 and 59A is a possession. And that's why BT correctly considered that the statutory override, which would have allowed BT to amend Section B to take that provision out, would have been an interference with property rights. It's right that Section B members have a property right to increases granted under 59 and 59A. What they do not have is a property right to the effect that the government will only increase the PCSPS under 59 or 59A. They have no right They obviously have no right to increases provided under other legislation, including under Section 1 and 2 of the Superannuation Act, and they have no right to insist that the government doesn't use powers under the Superannuation Act. They have no legitimate expectation that it won't. That's the point. And that's why we say that when the Divisional Court says that the concession that BT made about the statutory override means that the point we take on Article 1 of the First Protocol is a triumph of form over substance is completely wrong. There is a substantive difference between a situation in which BT is seeking the power to amend its pension scheme to take away a right that scheme members have, and a situation where all BT is asking is the government exercise the statutory powers it has in a way that doesn't impact on BT's pension scheme. Those are two completely different situations. Sorry, my lords, I think my phone is active. Can I just render it silent unless there is some louder eruption, which will be very embarrassing. So I was just going to show your lordships and your ladyship stretch and the United Kingdom, which is relied on by the Divisional Court, and we say inappropriately. So the facts of this case, we say, illustrate the boundary of what may be considered a legitimate expectation amounting to a possession or property right under Article 1 of the First Protocol. What's radical about this decision from the perspective of English law is not the substantive elements that give rise to the legitimate expectation, which entirely as you would expect. The aspect of it that's of legal interest to us is that it's held that a legitimate expectation arises where an unequivocal promise was made to an individual by a public authority, but that promise was ultra vires. So even though the public authority didn't have the legal power, as it turned out later, to make the promise that the individual had relied on, the fact that that promise had been made and relied on was sufficient to give rise to a possession. That's what's of legal interest. But the elements of the legitimate expectation, that it's quasi-contractual in the sense that there is an unqualified, unambiguous promise made by the local authority to the individual, that in this case they rely on, that those elements are all present. So what we see here, you can see from the head note, it's page 806, that the applicant was granted a 22-year building lease of industrial land by the local authority. The lease required him to erect up to 6 buildings at his own expense for light industrial use, and included an option to renew for a further 21 years. So he's incurring the expense of building 6 buildings on the understanding that he'll have an extra 21 years at the end of his 22-year lease. In 1990, the applicant was negotiating to renew the lease when he was informed the renewal option could not be exercised because, among other things, the local authority had exceeded its powers in granting him the option to renew the lease. Those are the facts. And if we come to the legal analysis, it's at page 815, whether there were possessions within the meaning of Article 1 of Protocol 1.
Which paragraph?
It's paragraph 32, my lord, page 815 at the bottom. And you see a summary of what possessions are at paragraph 32, and saying that they don't include a hope or a conditional claim that lapses because a condition is not fulfilled. Then there's a summary of the facts at 33. And then at 34, while it is true that under English law the option was rendered invalid due to the operation of the doctrine of ultra vires, the court observes that the applicant had entered into an agreement with Dorchester on the basis that he would have the possibility of extending the term of the lease. Neither party had been aware there was any legal obstacle to this term forming part of the applicant's consideration for agreeing to the contract. The applicant proceeded to build on the land, pay ground rent to the local authority, and enter into subleases with other persons who conducted business in the premises which he had constructed. He clearly expected to be able to renew the option and continue to obtain the benefit of rent from the occupation of those premises he'd sublet. He reached he reached a negotiation with the local authority, the stage of preparing a draft renewal lease with an agreed increased ground rent already signed on his side, and had proceeded to enter into agreements with his sub-lessees. The local authority only raised the problem of invalidity at a very late stage. The court considers, in the circumstances of this case, note those words, that the applicant must be regarded as having at least a legitimate expectation of exercising the option. Now, my lords, one can understand why the court reaches the conclusion that it does. And the only part of this that's ever been regarded as extending the English law on legitimate expectation is that traditionally, as a matter of domestic public law, you couldn't have a legitimate expectation deriving from an ultra vires promise.
Illegitimate expectation.
Correct, my lord. Correct. So that's the aspect of this case that's of legal interest. But in terms of the quasi-contractual or contractual elements, the promise and the reliance, it's a very, very strong case on the facts, which perhaps explains the result. Now, so far as the English law on legitimate expectation is concerned, it's been considered by the Supreme Court in two recent cases. The first is United Policy, I beg your pardon, the first is the Privy Council, United Policyholders. That's at tab 47, and I will hazard a guess that that is your authorities bundle too. So this concerned a situation in which the government, it's litigation that arises out of the financial crash of 2008, and the Trinidad and Tobago government took control of an insurance company that had collapsed and gave promises that it would pay outstanding claims. It later became apparent that it couldn't afford to do that because they were bigger than it had anticipated, and it said it couldn't meet the assurances. And the question was whether that was a breach of legitimate expectation. And ultimately, the case was decided on the basis that there were strong public policy reasons why the government had not met its assurances, and therefore it was justified in not meeting the expectations, whether they were legitimate or not. But in the process of that decision, Lord Carnworth engaged in a very interesting discussion of the scope of legitimate expectation, and that begins at page 1477 at the bottom of the page, paragraph 110. And he considers in particular the circumstances in which a legitimate expectation will arise. And what the essential point is that in order for there to be a legitimate expectation, you have to have a clear, unambiguous and unconditional promise or assurance made to a limited class by the public authority in question.
Clear, unambiguous
and unqualified. And in this case, he appears to say that there has to be detrimental reliance on that promise. As we shall see in a moment, the Supreme Court has rowed back from that and now says that detrimental reliance is a factor to take into account in determining whether or not there is a legitimate expectation. But the basic propositions remain. So I want to show you in particular how he deals with a question of a legitimate expectation that's said to arise simply from administrative practice, where there isn't said to be a promise. And this is at 115. He says, the approach has been refined in more recent cases where the giving and honouring of guidance or more specific undertakings by the revenue has been seen as part of the cooperative relationship between the commissioners and the public, ultimately part of the commissioners' tax collection functions. There are plainly circumstances when the commissioners can retreat from their published statements or rulings. In Davis against the Inland Revenue Commissioners, Lord Wilson quoted words of Lord Justice Moses to the same effect and added that to have legal effect, the promise or practice relied on must constitute a specific undertaking directed at a particular individual or group by which the relevant policy's continuance is assured. In other words, the taxpayers needed evidence. This is the critical passage. A practice so unambiguous so widespread, so well established, and so well recognised as to carry within it a commitment to a group of taxpayers, including themselves, of treatment in accordance with it. So yes, there are circumstances in which an administrative practice may itself give rise to a legitimate expectation, but only, in my submission, where the administrative practice satisfies these conditions, that it is so widespread, so persistent and unqualified that it amounts to an implied commitment. And finally, at 121, he summarises the position. This is at page 1481. He says, the trend of modern authority favours a narrow interpretation of the Cochran Principle, which can be simply stated. Where a promise or representation which is clear, unambiguous, and devoid of relevant qualification has been given to an identifiable defined person or group by a public authority for its own purposes, either in return for action by the person or group or on the basis of which the person or group has acted to its detriment, the court will require it to be honoured unless the authority is able to show good reasons, judged by the court to be proportionate to resile from it. Now, that's what he says there, and as we'll see, that is somewhat qualified by the later case of Finucane, to the extent that it is not necessary for there to be reliance. It's not necessary for there to be detrimental reliance. The existence of detrimental reliance on that type of representation is a factor, but not a necessity. But the need for an unqualified representation, or in my submission, an administrative practice of such a nature as amount to an implied representation with those qualities, it is an essential factor. The Finucane decision is at tab 59. This arises out of the appalling murder of a solicitor in Northern Ireland.
Which tab?
It's tab 59. It's at the back of the authorities bundle. And assurances have been given by the government of public inquiry into the circumstances of death, and the question was whether there was a legitimate expectation. And of course, it was very difficult for the family to show there'd been any detrimental reliance on any assurances given. And Lord Kerr, giving judgment for the majority, says detrimental reliance is only a factor, it's not a necessity. And you see Lord Carnworth, it's paragraphs 156 down to 160 at pages 1794 to 1795, where he qualifies the statement that he made in United Policyholders. Now, the final relevant case on this topic is the PSU case, which is somewhat more similar in subject matter than the ones we've been considering so far. The PSU is the Public Service Union. And what had happened, there are actually three cases in which this saga develops. As well as the principal civil service pension scheme, there is another scheme made under the Superannuation Act for civil servants, which deals with compensation for loss of office, deals with redundancy compensation. And the terms of that scheme are very generous. And following 2008, in line with the general austerity policy, the government made repeated efforts to reduce the generosity of the redundancy payments that were paid to civil servants. And the question ultimately crystallised in the third PSU case as to whether or not the entitlement to those redundancy payments was a legitimate expectation amounting to a property right under the European Convention. Now, the background was that historically, civil servants had been employed at the pleasure of the state, at the will of the state. So they didn't have a right, a legally enforceable right to notice, and they didn't have a legally enforceable right to redundancy compensation. Their redundancy compensation was always formally ex gratia, discretionary. But for generations, it was paid in accordance with specific terms of a scheme without exception. It was then crystallised in a scheme under the Superannuation Act. And what the court ultimately says is, it doesn't matter that formally it was an ex gratia scheme. In every practical sense, this was a universally applied scheme to which people had a legitimate expectation. And I just want to show the court the relevant paragraphs. The PSU case is at tab 51. And this is a Divisional Court called Justice Sales, as he then was, and Mrs. Justice Whipple. And we see the relevant discussion starting at paragraph 63. And the passages I want to refer to start at paragraph 68. And you can see that there is a citation of paragraph 35 of Kopecky, which we've looked at. And the point is made that the term legitimate expectation is an autonomous concept within the framework of the ECHR. Doesn't necessarily correspond to legitimate expectations of domestic public law, and they cite for that stretch. And the reason for the difference there, as I've already submitted, is because of the ultra vires nature of the promise in stretch. Then at 70, as explained in PCSU number 1, the entitlements to compensation payments under the CSCS are not matters of contractual right for civil servants. However, such payments were and are, in fact, paid in accordance with the terms of the CSCS as a matter of invariable administrative practice when the conditions set out in the CSCS are satisfied. In PCSU number 1, an argument was addressed to me that entitlements constituted enforceable legitimate expectations. It wasn't necessary to resolve that issue in that case. Resolution of that issue is relevant here because it bears on whether there's the entitlements constitute possessions for the purposes of A1P1. Mr. Sheldon submits the entitlements do not constitute legitimate expectations. I do not agree. It's established that consistent administrative practice in the exercise of discretionary powers can give rise to a protected legitimate expectation under domestic law. In my view, that is the position here. The claim for legitimate expectations for individual civil servants based on the stated entitlement of the CSCS is a particularly strong one, given the long-standing nature of the administrative practice in question. The entitlements in the CSCS are set out in clear and specific terms. They're akin to contract rights, as they would be if civil servants worked in the private sector and had their rights set out in contracts of employment. Civil servants are encouraged by publication of the scheme and the government's unvarying practice over very many years to apply the CSCS terms to expect that they will be paid in accordance with the CSCS and to rely on that expectation when making decisions in relation to their employment in the civil service. Previous availability of a right of veto for trade unions is not a critical feature, nor do I read the relevant paragraph in Mr. Justice McComb's judgment as indicating he thought it was. On that footing, that individual civil servants would have legitimate expectations in domestic public law, it's clear that they're possessions for A1P1. So there the court can see the kind of long-standing, very specific administrative practice implementing what is in every way except legal theory a quasi-contractual scheme gives rise to legitimate expectation. Entirely unsurprising. And then at 73, even if for some reason entitlements under the CSCS did not qualify as legitimate expectations in domestic law, they would still, in my view, qualify as possessions for the purposes of A1P1, on the basis they come within the autonomous concept of legitimate expectation in the law in relation to A1P1. The entitlements are clear and precise. They're invariably complied with by the government. They're akin to contractual employment rights, and they're given special recognition and protection under domestic legislation. Now, it's interesting that the court there says, even if they're not domestic rights, they're rights under A1P1, but the reasons that the court gives for why they're legitimate expectations under A1P1 are exactly the same as the reasons that the court's already given for why they are legitimate expectations in domestic law. There's no difference between those concepts. So that's the relevant legal framework. And in our submission, when that framework is applied to the facts of this case, it cannot be said that members of Section B of the BT pension scheme had any legitimate expectation that the government would not give increases to members of the PCSPS by routes other than Section 59 and 59A. That's the expectation that's asserted. Now, that expectation is said to be based on invariable administrative practice, that increases have always been provided under those provisions. Even if that were true, in our submission, it wouldn't be enough to give rise to a legitimate expectation. You're not looking at anything remotely comparable to the CSCS, where you've got a detailed, specific scheme that's quasi-contractual, but just happens to be technically discretionary rather than legally enforceable.
How far have you got to go on? As I said right at the beginning,
Yes.
we don't have anybody here representing the members of Section B. There's nobody here to argue their case. And the most it may be said that the Secretary of State has to do is to say there's a reasonable cause to apprehend they may have a case. Do they have to go, does the Secretary of State have to go so far as to say it's perfectly clear that they do have a case?
My Lord, what is clear from the documents I showed your Lordship earlier is that, in fact, the advice that was given, particularly in the November submission, which is the critical one, was that there was a property right, and that therefore doing what BT asked would be unlawful unless it could be shown to be justified. Can I just show your Lordship that again?
They do show me that, but you seem to be saying it's clear there wasn't a right. And
Well, Lord,
effectively you're asking the
Yes.
court to say, in the absence of one of the party, a critical party to this, that there was no right. And what I'm querying is that really the court's function to do that?
But my Lord, the position is, what the court is required to do is to say that the basis on which it's asserted that there was a property right is unsustainable. Now, if a particular individual BT pension scheme member wanted to come forward and say an unqualified assurance was made by BT to the BT scheme members in 1984 that their pensions would always be uprated fully for inflation. Somebody wanted to come along and say that, and that gives rise to a legitimate expectation. Nothing in these proceedings would stop them doing that. The point that's made here is simply that the government's argument is it doesn't say there was any such assurance. The government says there is a legitimate expectation that, not based on anything BT's done, that the government wouldn't use any route other than 59 or 59A simply because it hadn't done it before. Now, I do submit that as a matter of law, that is unsustainable. The BT pension scheme members were served as interested parties. The trustees, of course, here, and the trustee did not seek to make submissions on that issue on behalf of scheme members. Scheme members didn't seek to participate individually.
Well, I may be wrong about this, and please correct me if I am wrong, but I thought the point was it was considered not necessary to join the scheme members because on one particular point, in any event,
In relation to construction, that's right. But they didn't seek to join on any other point, my Lord. They didn't seek to. But in my submission, they rightly didn't seek to, because this argument doesn't preclude them from saying that they have a property right based either on construction of 10.2, which is specifically carved out, or based on what they want to argue in the future were specific promises or assurances given to them. That's not an issue here.
The trouble is we don't know exactly. One of the problems
Yes.
is that one can never anticipate what another party who is interested may or may not say. They're not here to say it. They may think of all sorts of things. I have no idea.
That's true, my Lord. But they've chosen not to be here. They've chosen not to be here. They were served. And our complaint is at the government's rejection of this route which is, in our submission, squarely based on the government's assessment that using a route other than 59 or 59A would breach property rights. And we say that was an error of law.
Well, what they say, to be fair, as it seems to me, is that there was a real risk there would be litigation. That's what there's a real risk there would be litigation, and that there was a low risk that it could be defeated. I'm not saying you're wrong.
No, but I just want to be clear as to why they say that. The reason they say that is they say there's a real risk of litigation, there is an interference with property rights, and the reason there's a real risk that we'll lose is because we may not be able to justify the interference. So it's not about whether or not there's an interference with the property right that they consider to be in doubt, it's whether or not it can be justified. That's the point that they're saying is the risk. Now, can I just show you, Lordship, the key...
What I'm trying to establish in this exchange,
Yes.
I'm trying to establish in a case like this, when there's a third party
Yes.
not present, what is the test, what is the standard by
Yes.
which the government's action is to be judged? That's all I'm
Yes.
trying to understand. And instinctively,
Yes.
one feels it would be wrong for the court to reach an absolute decision in relation to a matter which affects third-party rights who aren't here. Now, I understand you reply to that by saying, and I hadn't appreciated this, you say, well, they chose not to be here. I don't know the background to all that. You say they've been served. I don't know anything about that either. But assuming you're right about that, that's maybe one answer, that they had the opportunity to come forward and they chose not to do so. That may be an answer. But generally speaking, as I've said, now repeatedly,
Yes, I understand.
the court doesn't like to adjudicate in a final way on the rights of third parties.
Well, the other point is that it is the government that has adjudicated on the right. The government has positively determined this question on the basis that it concluded that there was a property right and that it would be interfered with by going down the PCSPS amendment route. Now, in our submission, that conclusion was wrong in law. Can I just show you where we say they reached that conclusion?
Yes.
First of all, it's in the November submission. That's supplementary bundle 1. Sorry, beg your pardon. Supplementary bundle 2. It's tab 26, and we've looked at these passages before. This is the advice on the basis of which the decision was made, and it was Mr. Kirk's evidence that this submission in substance contains the reason for the decision. And at paragraph 12, page 286, BT have suggested a number of solutions. The second is there identified as amending the 74 civil service scheme. And then TLA advise that in each case there would need to be a policy justification for preferring the interests of BT to the interests of the scheme members. The scheme rules have the result that members are entitled to benefit from an HMT direction in the same way as members of the 74 civil service scheme, and there would need to be a legally defensible justification for interfering with BT scheme members' property rights. So there your Lordship sees the positive assertion that it would be an interference with property rights. And you see it again at paragraph 13, where they say, well, we might be able to find a mechanism to avoid a knock-on impact on BT, but that would require identifying a legally defensible justification for the interference in property rights. That's paragraph 13. And then paragraph 15, and this is the point your Lordship was directly putting to me. Legal risk is high. A judicial review brought by members or trade unions is likely, and unless we were able to develop a defensible justification for interfering in property rights, there's a high risk of the judicial review being successful.
Do you balk at the first part of that, the assessment that a judicial review brought by members or trade unions was likely. You say that's not correct.
Well, I've no idea if it's likely or not.
It's not a positive part of your case.
Yes, it's not a positive part of my... No,
That's wrong.
no. My point is that the premise on which this advice has been given to the minister is that there is an interference with property rights. And that means that unless a legally sustainable justification that meets the A1P1 standard can be devised, they're likely to lose. That's the advice that's been given. And my lords, we see that advice given again to the Chancellor of the Exchequer in the later memorandum that's in the core bundle. This is the 30th of October memorandum.
What are we looking at now?
It's in the core bundle, tab 13. It's page 314. And you can see that the corrected legal advice at page 314.
Yes.
Were we to agree an exemption for BT, legal advice is that the risk of challenge is high and the chances of successfully defending such a challenge are low unless we were able to develop a defensible justification for interfering in the property rights of pensioners.
Yes.
So again, it's the same premise, and you see it again then, unsurprisingly, reflected in the decision itself. If we just go to the decision, which is in the same bundle at tab 12, the key paragraph 3.19. The bottom of page 303. The government believes it would not be appropriate to act in a way that would deprive members of indexation to which they would otherwise be entitled. Acting to do so would also raise legal questions, including whether there was a legitimate aim to justify such an interference in the property rights of members. So the premise of the advice and the premise of the decision is that there is an interference with property rights, and the reason there's a high risk is because they don't think they can justify it. And that infects the policy decision, because the interest they're weighing is regarded as a property right. Now we say that that analysis is flawed because the only promise that has been made to the BT pension scheme section B members is if the government makes a ministerial direction under section 59 or 59A for the PCSPS, you will get the same increase. That's the promise. There is no promise to the effect the government undertakes that it will not increase PCSPS pensions by any other means. Now, if we just go to the reasoning of the Divisional Court, so that's back in the core bundle. It's tab 5. And the analysis starts at page 70, paragraph 169. And you see that they start off by considering the meaning of possessions under Article 1 of the first protocol. They cite a case called Broniowski and Poland. Then they cite the familiar passage from Kopecky. And then they cite stretch at paragraph 173. The passages that we've looked at for stretch. And then they say the Treasury contended, this is paragraph 174, page 72. The Treasury contended that a similar analysis applies here, i.e. similar analysis to stretch. The Section B members entered into their agreement with BT in the expectation that any indexation of the PCSPS would be given effect through the increases legislation. So that's the expectation they're asserting. PCSPS pensions will only be increased through that route. And this necessarily on the footing that the government has other powers to do it. There can be no other reasonable explanation for their decision to contract. This is not a contract, of course. It's a prevalent error throughout this judgment, and indeed, the skeleton argument to suggest that the pension scheme is a contract. It's a pension scheme trust. It's not a contract. There can be no other reasonable explanation for their decision to contract in the terms that they did. That expectation has been borne out by the invariable administrative practice followed since then. Now, we say that reasoning is fundamentally flawed because you have a provision at 10.2 that's clearly limited in its scope and that refers expressly and only to increases under certain powers. And that is to be contrasted with the much broader provision of paragraph 1 of section A. If the intention was that BT section B members should benefit from any increase to the PCSPS by any statutory route whatsoever, why didn't it say that? Why did it specify only 59 and 59A? Now, we say there's a perfectly logical reason for specifying 59 and 59A. What BT is agreeing to provide is the minimum across the board pension increase that all public sector scheme members are entitled to as a matter of right because of the duty on the minister under 59. What BT is not agreeing to provide is additional pension increases that may be agreed between individual schemes and the minister to honour specific assurances given or to resolve industrial disputes. That's a perfectly reasonable explanation of the difference. And indeed, it makes no sense. If the intention was, as here suggested, why refer to 59 and 59A at all?
Are you suggesting, when you say BT is agreeing to provide the minimum across the board?
As provided for in 59, yeah.
Well, that's what I was going to ask.
Yes.
Because if you say what they were agreeing to provide was a minimum that was given across the board,
yeah,
that raises the question about what would be the commitment if the workaround by way of amendment to the PCSPS was made, because in those circumstances the pre-1988 GMP people wouldn't have anything, leaving aside the pre-1988, wouldn't have anything in the BT scheme which would guarantee them anything.
that's right.
So,
But that was never provided under Section 59. That was provided by a completely different statutory regime, the additional pension. So what is being said, and this is the basic error here, that Section 59 was never the means by which members of the PCSPS received any uprating to their GMP.
well, it was originally the AP, and then 59A provided a different mechanism.
Well, no, what 59A did was to supply gaps in the AP. But the primary mechanism by which most members of the PCSPS got uprating for their GMP was not 59 or 59A. It was either the AP or Section 109. And
109 didn't affect. We're talking about the pre-88 group.
Yes, but okay, the
Pre-88 group aren't.
Pre-88, before 1988, the principal mechanism by which the members of the PCSPS had uprating to their GMP was not Section 59 or 59A, it was through the AP.
Was it not, sorry, I'm getting a lot again, was it not through 109, as far as it went?
No, this is
Only-
pre-88.
pre-88.
This is, we're talking about 109 applies between 88 and 97. Yes. So that group have both. Pre-88 only have AP. Now, the core reasoning.
It may
of
be
the-
said that it may be said. Sorry, just to continue
Yes.
this discussion. It may be said that the reference, even before AP was abolished, it may be said the reference to 59A was a recognition that, as you rightly said,
Yes.
the idea was that there shouldn't be people who should fall through the system, that everybody should have the benefit of the 59.1 increases. Now, admittedly, it was provided by AP, but the reference to 59A, as you've suggested, is an indication that nobody, whatever their circumstances, whether they were abroad or not, should fail to benefit from the general increase related to social security, to social services benefits, something like that.
My lord, the difficulty with that proposition is that it's premised on the existence of a statutory scheme which has been abolished. The basis for that policy was the existence of the AP provision, and that's gone. And that's another reason why in our submission the whole legitimate expectation argument falls down, because this pension scheme was constructed in a world in which there was a two-tier state retirement pension, and no one had any reason to think it wouldn't continue. And what has now happened is that that world has fundamentally changed. The government has sought to patch the position because of commitments it made to its own employees, and is now seeking to extend that to BT. But the world, you know, the assumptions under which 10.2 were originally drafted are fundamentally different from the world as it now is. Now, can we look at the reasoning of the court?
Yes, sir.
Starts at 177 at page 73. The court says it's probably unnecessary to decide this issue, as the consultation response made it clear the government did not want to pursue an option that would involve complicated and contentious legal issues. That, of course, sidesteps my point that the policy conclusion was infected by the evaluation of this as a property right. If it is necessary, however, we would hold that Section B members' property rights are engaged in this case. The starting point is the terms of the Scheme B rules. We agree with the Treasury that the obvious assumption underlying 10.2 is indexation would be done using the increases legislation, and that in that way the Section B members would benefit as if their pension was payable under the PCSPS. That can be the only purpose of referring to the legislation, as it may have been or may from time to time be modified or reenacted. Now, in my submission, that presumption is flawed for the reasons I've already given, not least that the primary route for uprating GMP has never been this legislation. It was originally the AP and then the AP plus the 93 Act and amendments to the scheme rules. Building on that, it's the fact that the invariable administrative practice since then has been to use the increases legislation for indexation increases. Factually incorrect, as we've already considered. In fact, the only time that this legislation's been used in anything remotely approaching these circumstances is 2016, and then on an expressly interim basis. And here we see the eliding of pension scheme increases with GMP increases.
How much longer are we going?
I'm very close to the end, my lord. I can finish if your lordship's prepared to give me 10 minutes.
Yes.
Thank you. And you see they rely on his quote in relation to 59A direction. The invariable practice from the outset of the old two-tier state pension was the Treasury direction be used to switch back on full indexation in any circumstances where that would otherwise not be provided by the AP. Firstly, of course, those were only the exceptional and anomalous cases, and secondly, again, not true, because of the operation of section 109, which is simply ignored in this analysis.
So were you reading from just there?
Sorry, just above paragraph 180, a quotation from Mr.
I
Kirk.
see. Oh, yes, I see.
Then they make the point that it's BT's own case that the right that would be interfered with by the statutory override is a property right. We say true, but so what? They then say, at 182, whilst the statutory override is a more overt interference with that right than the PCSPS workaround, and that it enables the right to be removed rather than circumvented, the aim and the practical end result is the same in both cases, as is the underlying right being interfered with. In those circumstances, to draw sharp distinctions between them is to elevate form over substance, which the Strasbourg Court generally deprecates. Now, in my submission, this paragraph is, with respect, hopelessly flawed. To say that the exercise of a power to change the terms of the BT pension scheme to permit the removal of an entitlement under Rule 10.2 is in substance the same as the exercise of a pre-existing statutory power in such a way as not to engage 10.2 is just wrong. The court uses the pejorative term circumvent, but it's simply the difference between changing the substance of a right, which the statutory override would, and operating within the outside the boundaries of a conferred limited right. Then they say we do not consider that the consultation changes matters. We were making the point that the 2016 consultation made it clear that all options were on the table, so that nobody could have expected from 2016 onwards that the GMP would continue to be indexed only under section 59A. It was obvious that all options were on the table. While that contemplated new legislative options being taken, it did not suggest that if instead full indexation was to be continued on an interim basis, that would lead to any change in the conventional means of achieving indexation, namely through the increases legislation. Again, erroneous to suggest that the increases legislation was the conventional means of indexing GMP. It was not. And then they say you can have an A1P1 right that isn't a domestic property right. They don't say how or why the two are different, and then they say that they uphold Ground 5 and say there is a property right. Now, the court will, I think, have seen why we submit that analysis is wrong. That they fail to identify any administrative practice sufficient to meet the test for legitimate expectations set down by the Privy Council or the Supreme Court, whether in domestic law or Strasbourg law. My Lords, my Lady, unless I can be of any further assistance, those are our submissions, and we will endeavour to have some sort of draft for the court tomorrow morning.
Very helpful. Thank you very much indeed. Thank you very much indeed. 10:30 tomorrow.
All right.